My name is Laura Tamez, and I am past president of Texas Trial Lawyers Association. I am here testifying on their behalf, respectfully in opposition to the original file bill. I want to express my gratitude to Chairman Spiller for listening to our concerns and encouraging a stakeholders meeting where we did make some progress, and we talked about the committee sub, and we don't have any concern with the one provision that they added or the one clerical error that they added. But let me start by saying also that these high voltage power lines at 7,200 volts and what that does to the human body, it either maims or kills. And it's one of OSHA's fatal 4. So this bill impacts not just our journeymen, our linemen, but it's also going to impact tree trimmers, other contractors, and homeowners. And so there have been some cases that have popped up recently in the appellate courts discussing homeowners that may have called the utility company complaining about trees in the lines, and utility company might have said, y'all need to handle that yourselves. They hire a tree trimmer, and the tree trimmer doesn't call the utility company 48 hours preceding the performance of the work. So we appreciate that they are trying to fix some ambiguities in the bill. But the Chapter 752 of the Health and Safety Code has an indemnity provision that's already punitive in nature. So if there is someone who does not call the utility company within the 48 hours of performing the work, and there is an electrocution or an electrical injury or damage to the power line, then the indemnification provision indicates that whomever that person is must pay for any damage to the lines. The provisions that are concerning now that have been added on page 8, line 15, is the limitation of liability. And in the event that there is an electrocution or electrical injury, that this turns into more than just an indemnification provision, but it bars the person who is performing the work from a right to a civil jury trial to adjudicate the utility company's cause or contribution to the cause. And when we talked about with the stakeholders, the good news is that we want to continue the conversation to make it a more balanced bill. The other concerns that we have is it codifies joint and several liability, which is really within the province of the jury, being that we're a Chapter 33 state, and plaintiffs will, at 51% or more negligence or causing their own injury, are barred, right? So there's some affirmative defenses that are available that we are going to visit on and talk through, as opposed to just, one flat immunity bill where the conduct can't be adjudicated. The other provision adds attorney's fees and costs, and there is a case where a person who was electrically injured had the court assessed $500,000 in attorney's fees against that particular person. So that is in existence, but this kind of legislates it. So we're going to talk about that, and then the accelerated appeal provision of the bill when it comes to the indemnification provisions. So I'll end with I welcome the opportunity, and again, very grateful to Chairman Spiller and to Encore for visiting with us about our issues, and hopefully we can get to a more balanced bill. Happy to take questions.
Thank you, Laura. Members, any questions for the witness? Okay, appreciate your testimony.